Hi everybody, this is Joel Wood, your lobbyist here in Washington. Hope you're doing well. Congress was in session this week, the House and the Senate were, but all eyes were transfixed on the Supreme Court, obviously during the oral arguments. 6.5 hours worth of oral arguments that were fascinating, at least to me, to be able to hear them almost in real time to be released on the day of the oral arguments. And I think there was a considerable amount of surprise among most observers, particularly in the insurance industry, over the disdain that many justices seem to show for the notion of severability, of pulling out if the individual mandate is declared unconstitutional, what happens to the rest of the act. And I think most of us have believed that if the justices were going to take any action in opposition to the act, it would be strictly limited to the individual mandate. It's again way too early to be able to read into the oral arguments as to what the justices are actually going to wind up ruling on. But I would say that if the act is declared unconstitutional as a whole, obviously Republicans would rejoice and Democrats would be quite defeated on it. On the other hand, I don't believe that this is going to foretell anything in particular on the election results themselves. People's views on Obamacare and the Affordable Care Act are pretty much baked in. People that love the president love the act, and vice versa. As Charlie Cook, our political guru, noted in a great column this week, he said, the Affordable Care Act is like a political Rorschach test. Everybody sees into it what they want to see. What I think is really fascinating about that decision, however, that the Supreme Court might not view the individual mandate as severable from the rest of it, is that the administration's viewpoint is that if they pull out the individual mandate itself, the only other provisions that would be removed are guaranteed issue and community rating, the whole pre-existing conditions restrictions issues. And so we even saw some health insurer stocks that were sort of falling and rising on the basis of what the justices were asking about on that front, because I think the worst nightmare to health insurers is that the Supreme Court would declare that the architecture of the Affordable Care Act would move forward with the exchanges, with the subsidies, with all the other provisions, and the individual mandate, which at least brings in the young invincibles and brings tens of millions into the marketplace, would be unconstitutional. So this is going to be extremely interesting. Finally, today marks the day of the first meeting of the Federal Advisory Committee on Insurance before the Treasury Department. This is a creation of the Dodd-Frank Act. It's associated with the creation of the Federal Insurance Office. Brian Dubrow of Marsh is representing the brokerage industry there. Couldn't have a better representative there. A number of other superb players in the industry that are on it. I think it's, but it's an advisory committee. I think this is mostly important from a symbolic standpoint, that it marks the first ever official advisory committee to the federal government on insurance issues, on the full range of insurance issues. I found it very interesting, though, that the Conference of State Insurance Legislators actually put out a press release denouncing this advisory panel because it doesn't have a state representative or a state senator on the panel. Meanwhile, it does have state regulators and other various industry sector representatives and consumer representatives. I liken this a little bit. I'm reminded of back in the 1970s when then Senator William Scott of Virginia held a press conference because a Ralph Nader-linked organization had declared him to be the dumbest senator in the United States Congress. And he held a press conference to say, in fact, that he was not the dumbest. So I'll let you draw your own conclusions about that. Hope you have a great week. Talk to you soon.